Hi everyone, welcome back to Immigration and Jobs Talk Show. I am Rajni Bharara, your host. And before I move ahead, I would like to read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right. After this very important disclaimer, welcome back, everyone. I'm Rajni Bharara, your host, and today we have an incredibly important topic to discuss. One that affects many Indian owned businesses across the US and their employees. Recently, there's been a growing concern that the Department of Homeland Security, or DHS, is secretly blacklisting Indian owned companies. This has led to visa denials, visa revocations at ports of entry, and in some cases, serious disruptions to businesses and employees. Many of these companies are in the tech sector, which relies heavily on foreign workers, particularly those from India. But here's the catch: DHS doesn't legally have the authority to sanction or punish companies like this. That power belongs to Department of Labor, which must follow strict legal processes involving notice, trials, and appeals. So, how is DHS getting away with this? Why are they targeting Indian owned companies specifically? And what can affected business and employees do to fight back? To break this down for us, I'm thrilled to welcome back our special guest, Jonathan Wasden, a leading immigration litigation attorney who has been at the forefront of fighting these kind of legal battles. John will help us understand the legality of these DHS actions. Like I said, John will be helping us to understand the legality of these DHS actions, how they are being carried out in secret, and most importantly, what steps companies and individuals can take to protect their rights. We'll also dive into the bigger picture, whether this is a part of a political strategy, how it impacts immigration policy, and what it means for future of foreign-owned businesses in the US. So without any further ado, let's get into it. Welcome back, John, once again to Immigration and Jobs Talk Show.
Thank you. Good to be back with you.
Thank you so much. It's always a pleasure having you back. And John, like I said in the introduction, this topic of today is a very critical one and a very important topic. So my very first question to you is, why do you think DHS is targeting Indian-owned businesses specifically?
So it's no secret that DHS has a longstanding dislike of the Indian IT consulting businesses. And they've tried numerous different ways to eliminate them from the H-1B program, all of which have failed in one form or another through the litigation and courts process. So what we're seeing is their latest attempt to eliminate these types of companies using, ever more questionable legal basis.
Okay. But John, like I said, do you think there could be a political aspect to it as well?
So, under the Trump administration, definitely, because the Trump immigration advisors were completely simpatico with the executive level of the agencies on this topic. The Biden administration doesn't seem to be quite so antagonistic, but it's important to realize that you have the political appointee level at an agency that has to get appointed by the president, confirmed by Congress or the Senate. And then you have the career executive level. And the career executive level are people who have been promoted through the bureaucracy, and they have been selected to be at the executive level by people who think the same way as them. And so those are the real powers and the real people behind the scenes that are making decisions on policy. And political appointees can come in and they can have great ideas, but if they don't have the buy-in from the executive level civil servants, those great ideas die because the bureaucrats know how to work the game much better than the political appointees, and they'll use every dodge and every trick in the book to thwart policies that they don't agree with.
Right, right. And John, also, could this be seen as a form of racial profiling or maybe discrimination by DHS? And if it is, then how would that factor into legal challenges?
So legal challenges on national origin discrimination and immigration are tough because, yeah, by its very nature, immigration law discriminates based on national origin. As we see in the federal law, the per country limit is a great example of that. So those types of claims are very difficult. What we think is the more effective approach is to attack the agencies via the Administrative Procedures Act, the Privacy Act, and Freedom of Information Act.
Okay, okay. And you also mentioned when you wrote that post, you also mentioned in that DHS is acting without proper legal authority. So how is DHS bypassing the Departments of Labor role in sanctioning companies?
Sure. So when you look at let's take the H-1B petition process. You first, go to the Department of Labor, and then you go to USCIS and you get the petition approved. During that petition process, if they had legal authority that was unquestioned, then USCIS would be making those decisions, barring an employer from participating in the H-1B program. And then they would issue a decision to that effect, which could be easily challenged in court. Because they don't have that authority, what they're doing is skipping the adjudication process. They're approving the petitions that are coming up for review. But then they're waiting for the employees to go for stamping or to hit the port of entry. And only then are the employees being told, yeah, your company has been blacklisted, or words to that effect, and we're denying your visa. And so that's where it comes in. And the reason why they do this is simple. Because they can't get sued typically on a denial at the port of entry or the denial of a visa at the consulate. So DHS has taken the calculated step to say, we know we can't do this, but if we do, this is probably the most successful way to avoid a court looking at what we're doing.
Okay, okay. So do you believe this could be a coordinated effort maybe between multiple agencies to curb immigration through informal sanctions?
So I think this is really just a DHS problem, but
Okay.
DHS does communicate to the State Department. They do work very closely on things, and they have a shared database that they use when adjudicating visas and also, at the consulate when they approve the visa. And if you're flagged in that system, the consulate takes the position that they can't do anything to overcome a DHS flag. So the applicant will have to go to DHS to fix any flags before the consulate will approve the visa. And so you're in kind of a catch-22. The consulate doesn't really have a dog in the fight, but they're being told they can't override DHS. And DHS is basically impenetrable. There's really no way to get to DHS and say, hey, what's going on? And even when you typically do file a FOIA, they give you a non-response. And so it can be very frustrating if you're in this situation. But getting back to your point about the legality, all federal agencies, when they compile information or lists or anything related to an individual or a company, they're required by federal law to publish that they are collecting that information. It's called a System of Record Notification, or a SORN. And that SORN informs the public, hey, this is what we're doing, and this is what we're using it for. So when we're talking about blacklists and something where the agency is compiling lists on companies that are somehow eliminated from the H-1B program, that has to go into a list. And that has to be maintained in a system of records. And here we see DHS has not published this information, and they haven't published that they claim to have authority to be able to blacklist companies. And so that's the first violation that we're looking at, is their failure to comply with the Privacy Act and their failure to publish to the world what they're doing. And the next issue is, do they actually have the authority to do that under the Immigration or Nationality Act?
Yeah.
And it's very clear that they don't. The only agency that does have that authority is the Department of Labor. And labor has a very complex, very lengthy enforcement process. It starts off with a notice to the company. Then there's a administrative trial. The agency has its own kind of trial court. And if you dislike that, then you can appeal within the agency. And if you don't like that, then you go to federal court. And so, you know, Congress dictated how companies are to be sanctioned. And it's through that Department of Labor process.
Mhm.
DHS has created something out of whole cloth that is at odds with what Congress wanted to happen.
Right, right. So also, John, if DHS is blacklisting companies and revoking visas without legal grounds, so why hasn't there been more significant public outcry or maybe court challenges from the affected businesses?
So it's the way that they're doing it. So they're
Okay.
they're very cagey about it, right? So like I say, if they really thought that they had legal authority to do this,
Mm-hmm.
they would make their decisions in the petition process and say, this employer is not eligible, they're blacklisted because. But before blacklisting an employer, they would first have to give that employer notice, opportunity to respond, and make a written decision as to the employer that they're somehow unable to participate in the program. And then once that decision is made, it could be challenged in court. And if it's not challenged in court, then future applications could be denied. But they're not going through that process. They're not putting the employers on notice. They're not giving them a chance to respond. They're doing everything in secret because they clearly know that they don't have authority to do what they're doing. And, in their view, the easiest way to avoid court challenges is to not tell you or not put anything in writing. And so what we're seeing is when people go to the consulate or they go to the port of entry, they're denied. They're being anecdotally told by individual officers as they're looking at the screen, oh, your petition was for a blacklisted employer. That's why we can't give you a visa. But they're not giving anything. All we have is the reports from employees from consulates and ports of entries all around the world saying, yeah, I was told by a government official that my company is blacklisted, and that's why they denied the visa.
Right, right. And could this also be a reason that it might be happening because the companies are unaware of their legal rights or maybe they fear retaliation if they challenge DHS? Could this also be a reason?
Fear of retaliation from DHS, I think, is probably one of the more overrated concerns that people have.
Okay.
The reality is, you know, if DHS is doing something wrong and you push back and you fight back, they're going to try and stay away from you in the future because that pushing back and going to court costs them a lot of time and energy and money.
Mm,
And from my experience, both inside the government and outside the government, if there's one thing government employees want to do, it's avoid additional work that they're not paid for. And so, historically, the people that have been the most aggressive in litigation have been treated the best and the most fair because of the agency's just inherent desire to avoid work.
right, right. And what about the legal rights? Could this also be a reason that the companies are unaware of their legal rights?
Yeah, I think definitely that companies are probably unaware that A, DHS doesn't have the authority to do this, and that B, there's a way that they can, fight back. It's a lengthy process and it takes some time. But if your lifeblood as a company is bringing in foreign talent and foreign labor, and that's being cut off from you, it's really an existential problem for you. You either fight or you die.
Right, right. Also, so, given the secretive nature of these blacklisting practices, so, John, what avenues of legal recourse do affected businesses have to uncover what DHS is doing and holding them accountable for?
Mhm. So the first thing is you have to, gather your evidence.
Okay.
So when you have employees that are going through the port of entry, or you have employees that are going to the consulate and being told that the company's blacklisted, you've got to get statements from those employees in as much detail as possible, everything in the world that they can possibly remember about the conversation. And then you have to get that put together in a declaration. When you have a certain critical mass of those, then you do your FOIA, your Freedom of Information Act request,
Mhm.
pushing for documentation or something from the agency disclosing the blacklist, which they will almost certainly deny. Then you
Right.
appeal your FOIA, and if they deny that appeal, then you go to federal court. And you go to federal court suing on two different things.
Mhm.
One is the FOIA, requesting the information and having the court order the production of the information. And then the other thing is just challenging the illegal blacklist process for failure to comply with the Privacy Act, for failure to comply with the Immigration and Nationality Act, and failure to comply with the Administrative Procedure Act.
Right, right. Thank you so much for answering the question, John. I still have a lot of questions, and I can see a lot of people joining us. Rag is here. He says, "Hello, Rajni and John." Hi, Rag. I hope you're doing good. And Anusha is also here. Namrata Reddy. They have posted a lot of questions. So, Rag, I would like to take your questions, but in a bit, let me ask John a few more questions, and then definitely I'm going to take your question first. So just please, be patient. I definitely will be taking your question. So yeah, here he is. But John, I wanted to ask you a follow up. So are there any examples where companies have successfully fought back against DHS, and what did they do to fight back?
So the blacklisting has really accelerated most recently in the last couple of years. And as yet, companies haven't gone to court on this issue. And it's something that we're developing a strategy to work with companies to do.
Mhm.
But again, it takes time. And so I think we're a ways off from having a court decision on this issue. But we're laying the groundwork right now in the foundation for a case that will have the best chance of success.
Right. So also, John, how can these Indian-owned businesses avoid being unfairly targeted?
So there's really no way to, you know, accurately predict what an irrational government agency is going to do. So it's
Mhm.
hard to say. I've seen companies with the most legitimate profiles, the most, you know, compliant practices be in the situation just for the mere fact that they do, third-party placement or consulting. So I don't know that there's anything you can do because compliance with the law definitely isn't a shield or a protection. All it takes is, one disgruntled FDNS employee to write a bad report, and that could be enough to trigger the process and cause problems for the company in the future. So it's really hard to say that there's a way that you can act that is going to make you bulletproof. I think what you can do is be reactive. When you're hearing this type of information from your employees, that's when you start having to line things up and sue.
Okay. Okay. But does this behavior by DHS represent, a broader trend of government overreach in immigration enforcement?
I would say in general, since the Trump administration, DHS in particular, their fidelity to the law and their respect for law has dropped, and their need to comply with procedure in the law is definitely not well respected within the agency. So I think that's a disturbing trend. I don't know that it applies to all agencies. I think most agencies are a little bit more diligent in following the law, but DHS definitely feels a little bit emboldened post-Trump administration to be creative and not necessarily be bound to the law.
Okay. If this is what they mean by being creative, wow. Uh,
Yeah.
right. But John, but about the businesses, are there any warning signs that the businesses should look before DHS takes an action against them?
So, the only thing I would say is they have to be very diligent with the FDNS site visit process. You have these FDNS officers who are poorly trained, have no idea about, how businesses actually operate, and they're just looking for information on a checklist. They have no technical background to determine, what your employees are doing. And it's very easy for them to make honest mistakes and misconstrue what's going on, as well as make completely erroneous legal determinations because all they're doing is what their superiors have told them to do, and they're just following rules that have been given to them. So because factually and legally they don't know what they're doing, their reports can be damaging. And so it's important for companies to make sure that they are represented during every site visit process, and for the employees to know that they're represented, and that they do not communicate directly with the agency. The law allows you to do all correspondence through an attorney. It gives you the right to representation. I would strongly suggest to people that they take advantage of that right, and that they don't try and wing it themselves, because you don't know what that agent's going to be using that information for. And you may be completely in the right, but inadvertently say something, and that is going to cause you problems for a long time to come, especially for the employees, because in the H-1B process, an employee during the petition process has no communication with the government, which means that it's virtually impossible for them to make a false or misleading statement that would trigger a lifelong fraud finding bar. The only time they really communicate with the government is during the site visit process. And so they can be incredibly vulnerable during those things to coercive agents who are, threatening them and trying to get them to say something that's not true just to make their report better. And so it's important that they have an attorney there representing them, getting between, what could be an overly abusive government officer and the employee.
Right, right. Thank you so much for answering the question, John. I again would like to come back to my questions, but in a bit, let me quickly take Rag's question. So, Rag actually wants to know, does the DHS publish a directory of blacklisted companies anywhere?
No. And, this is really frustrating if you look back at the recent, scams that were targeting Indian nationals by companies like Integra, Wireclass, and Will. DHS was watching these companies for a long time, and they had blacklisted them, and they had realized that they were scamming and defrauding Indian nationals that were in their OPT program. And so instead of alerting the public to it, they stayed quiet. They let the scam and fraud go on. They let these people be victimized. And then instead of really taking action against these companies, they started penalizing the victims of the fraud. And so the same or similar thing is going on with blacklisting these companies in the H-1B space. Is DHS is not publicizing who they think are problem actors. They are just monitoring it and then waiting for the employee to go to the port of entry or the consulate and being hit with, a visa revocation or visa denial. And that really only punishes the employee, especially at the port of entry. Because if they're denied a visa or they're expeditedly removed at the port of entry, that can trigger a 3-year bar to even reapplying to the US for admission. And it definitely blights their record for the future. Anytime they try to get a visa, that's going to be a flag on their system. They're going to be asked about what happened. So, DHS is definitely not interested in informing the public of potential threats or people they think are misbehaving. They're just sitting back and basically penalizing the employees later on for, working for companies that they don't like.
But how are they monitoring? What is the process of the monitoring, John?
So monitoring
The
which,
businesses.
so again, that gets back to this whole concept of a system of records. So when the agency collects information, they're supposed to tell the public that they're collecting it and what they're using the information for and what their legal basis is for that. Now, in this situation, they are not publicizing it to the public, but they are definitely maintaining these records internally. And they're flagging, petitions and flagging employees that are working for certain companies in the system. And that's the only way a consular officer, thousands of miles away, or some random CBP officer, at an airport is going to know that your company was blacklisted. So, one second. Yeah, so that's the only reasonable way that you can explain that you're blacklisted is that they have a list that they're sharing and maintaining across the entire system.
So are they picking a particular kind of a business or okay, I think something happened there. Okay, John, you're back. Um, so I was saying that are they picking a particular kind of a business or are they targeting, uh-huh.
And so I've seen, Indian restaurants. I've
Okay.
seen, IT companies. It really just kind of runs the gamut. Anybody that's filing H-1Bs that seems to be Indian owned is having issues.
Wow. Okay. Is it happening because of because they are also getting accused that the companies are exploiting the H-1Bs? Is it why? Do you think this could also be a potential reason behind this?
Again, if they were actually concerned about the employees,
Hmm.
they would be publishing the lists of who's blacklisted to give the employees a heads up and fair notice. I think their approach, honestly, is to hurt these companies by depriving them of employees. And, the way they're doing that is just flagging the employees in the system and getting their visas denied or, turned away at the port of entry. If they thought they had legal authority to do this, they would be following the Administrative Procedure Act. They would be giving the companies notice that they're going to be blacklisted. They would give those companies the opportunity to respond, and then they would issue a written decision, a formal decision with the sanction or the punishment or the penalty. That could then be challenged in court. The fact that they're not going through that process tells me that they know what they're doing is not legally justifiable. And so they're looking for any backdoor way they can to do this.
Okay. So Rag is actually back with his question, and he says, "Can DHS be subject to data privacy, GDPR, California law infringements?"
So they're going to be controlled by federal law. And the federal law that is going to come into play here is the Privacy Act and the Freedom of Information Act and the Administrative Procedure Act, as well as the INA, the Immigration and Nationality Act. So under the Privacy Act, they're required to disclose that they're keeping records on people or companies and disclose what they're using that information for. And failure to disclose that is actually a pretty big offense that individual government employees that are maintaining the list could be punished for. So it is something that has teeth, but it takes a long time to build the record and prove that this is actually going on. I think the strongest way to do that would be some type of collective action when you have multiple employers who are facing the same thing across the board coming together and fighting this all in one. But you know, that's the background there.
Right, right. Also, Rag, I hope you have got your answer. Thank you so much for your question. If you have a follow up, please continue posting it. We'll be glad to take it. And John, but do you think is it possible that DHS is targeting these Indian-owned businesses? Could be a politically motivated, uh, case. And given the current geopolitical climate between US and India, though it is being shown on media that they are having good relations, they are signing deals, things are happening nicely. They have also opened, I think, 250,000 slots for Indian nationals to apply so that they can apply visa and travel to the US. But still, could this also be a reason?
I don't know that it's happening at the political level of the agency,
Mhm.
meaning, the people that are appointed by Congress that are working directly for the president, and carrying out the president's policies. I really think this is more at the what's called the senior executive service level and the executive level of the agency of career people, people that aren't appointed by Congress. And, they have a well-established and long-standing bias against, especially the Indian IT consulting companies, and they have tried everything they can in the book to, you know, eliminate them from the program, and they've lost at every turn. And I think this is just the latest manifestation of that bias, is the way they're handling the situation.
Wow. Okay, okay. But John, how do international relations otherwise influence domestic immigration policy? And is there any precedent for this?
So definitely, at the political level, that there can be concessions made on immigration issues. But when it comes down to it, unless there is a real restructuring and cleaning of the house within DHS itself, those career people really have a disproportionate amount of influence on the way things get done. And as long as those career people with a bias are there, it's going to be difficult to make a real meaningful impact if you're the political people. So, the political people can have all the greatest ideas in the world, but if that senior executive level of the agency doesn't like it, they will use every tactic they can to delay and slow roll it and make it die in its tracks.
Okay. But also, John, what impact does these blacklisting and visa denials have on the employees of these Indian-owned companies, particularly, H-1B and L-1 visa holders?
Yeah, so that's the real travesty, is that if they go to the port of entry and they get expeditedly removed because of this, that impacts them directly for nothing that they've done wrong. And so they could be looking at having a 5-year bar to reentry to the US just because of this blacklist that they're unaware of. And, even on a lower level, if you go to the consulate and get your visa denied, you're going to be flagged in the system forever for having a denied visa. And every time you go in for a visa stamp, you're going to be questioned about that. And you're going to have to go through the whole process all over again and to discuss, what happened. And it's, the denial is not going to be something that was caused by the employee. It's going to be, as a result of the blacklist that the employee was completely unaware of. So, the employees do bear the brunt of this. DHS doesn't have any legal authority really to punish the companies or to penalize the companies. The only thing they can do is deprive those companies of employees. And in their mind, this is the most effective way to do that.
Okay. And actually, Rag is also back and he says, is the L-1 visa liable too?
I think, any visa, especially if we're talking about an Indian consulting company, is, potentially going to be impacted by this. By just sheer weight of numbers, the H-1B is the 800-pound gorilla, or that's the biggest game in town. And I think, H-1B centric companies are going to be at a higher risk just because they have more interaction with the agency, and they just have more exposure.
But also, John, talking about the employees here, so can the affected employees, take individual legal action against DHS, or this solely is reliant on companies' legal efforts?
So the employees, if they're expeditedly removed at the port of entry, they can do a waiver request. They can work through the trip process. If they're denied a visa at the consulate or put into 221G at the consulate, they can try and work through LegalNet to get that resolved. And those are the only real options that they've got, because what we're dealing with is decisions made by CBP at the port of entry and a consular officer overseas. And Congress has determined that those are two decisions that are basically immune from attack by the individual. And so they don't really have any legal basis to go to court just solely based on those decisions.
Okay, okay. And again, Rag asks, okay, let me quickly take firstly of Rag. He says, any class action suits running against this?
Not at the moment. The trouble with a class action is that you have to show that there's an entire group that have the exact same issue. And when we're talking about these cases, it's all anecdotal evidence that you have employees going to the consulate that are being refused because of a blacklist. And really, I think each individual company is going to have to go to court to advocate for themselves when this happens.
Okay, but also, John, is there an opportunity to challenge these actions on constitutional grounds?
So I think it's more of a statutory violation. You could, conceivably make out constitutional claims, but I don't think ultimately those will be what the case is successful on. I think really it's going to be more on these procedural grounds. Did they follow the Privacy Act? Did they comply with the Freedom of Information Act? And did they comply with the Administrative Procedure Act? Those are the easier issues for courts to decide on. And, when you're suing the government and you have both a constitutional claim and a statutory procedure claim, if the court can rule on the case on the procedure, they always will, just so they don't have to touch on the constitutional claim. So, realistically, the statutory procedure claims are where this issue has to be fought.
Okay, okay. Um, okay, I think, Rag, I hope you have got the answer to all your questions. In case you have any more, please continue posting them. Meanwhile, let me quickly take Vishnu's question. Vishnu is also here. He says, following a DHS investigation, our Indian-owned software development company faced negative media coverage and lost significant clients. What legal avenues can we pursue to address reputation damage? And second, recover financial losses, and third, prevent future disruptions?
So each case like that is individual and would really have to look at the facts. There is something called a Bivens lawsuit where if you could, look at and see an individual government employee did something like that, disclosed information to the public that should not have been disclosed, and they did it with animus to try and hurt the company, then you could individually sue that government employee. But those cases are tough, and without more facts, it'd be impossible to say if that's actually an option in that case.
But John, when you say facts, what kind of facts are you talking about? What exactly you mean?
So, what was the investigation? Which agency office performed it? Was it HSI? Was it ICE? Was it FDNS? What type of information was released to the public? Who released it? All of those different kinds of issues.
Okay. Okay. So Vishnu, I hope you have got your answer. In case you have a follow-up, please let us know. Rag is again back. He says, any preemptive guidance for the employee to exercise caution before jumping in?
Yeah, I think for the employee especially, when you're going to the port of entry, you should have a Form G28. That's the notice of appearance of counsel or authorized representative. And that's something that you should have signed with an attorney prior to going to the port of entry. If you have that document between you and the attorney, between the company's G28 is not going to count. But if you have a document between you and the attorney, if there's anything or any problems that come up, then your attorney can communicate with CBP on your behalf and discuss any legal issues. Without that, you're on your own. And there's not much that anybody can do for you when you're at the port of entry and you get put into secondary. The one thing I would caution everybody out there, and it shouldn't be any surprise at this point, but CBP officers and sometimes even consular officers, when they take you into a secondary environment, they will threaten, they will yell, they'll scream, they'll intimidate you, and they'll present you with a story and try and force you to agree with their story. And then oftentimes with CBP, they'll have you sign a statement that they've created, explaining how you did something wrong or you knew something was wrong. And their big threat is, we will, deny your visa, or we will, deny you entry and you'll have to go back to India. Well, if you're in that environment and they're being that coercive anyway, that's going to happen regardless of what you do. So don't make your situation worse by signing a statement that's not true or agreeing to something that's not true just to, make the CBP officer happy and leave you alone. They're going to remove you no matter what at that point. So if they start getting aggressive and nasty and belligerent with you, ask if you can withdraw your application for admission and say nothing else.
But John, if one person does, they choose to sue them, then what is the time frame that they're looking at?
So for the companies,
Yeah.
so if the companies, sue, what they've got to do is first Freedom of Information Act. And there's certain things that they've got to ask for in that request. Things about individual information about the company, internal policies and procedures that the officers followed to compile the blacklist. And then when it's denied, they have to appeal the FOIA to the agency. And after the agency has denied the appeal, then they can go to court. When the agency comes in and says that there is no information available to suggest that there's a blacklist, which they almost certainly will, and you've got declarations from your employees describing in great detail what happened at the port of entry and what happened at the consulate, then DHS's version of events is going to look incredibly weak to the government. And typically what they'll do is, the existence of any information that's going to be negative or damaging for them, they'll withhold, and they'll give a explanation that says we've withheld information because of it's law enforcement sensitive. But that law enforcement sensitive claim is something that the court decides. And if you've got evidence showing that there's something fishy going on, the court's not really going to respect that law enforcement sensitive, most likely, because this isn't a law enforcement issue. Law enforcement implies that there is law that they're using to punish somebody or take action against somebody. DHS has no legal authority to blacklist. And so the law enforcement exemption really doesn't apply in this situation.
Okay. So, Akshay, I definitely am going to take your question. Please, you'll have to wait for a bit. Let me quickly take Rag's question because I think it's just a follow up to this. He says, is the attorney access available at the consular level?
So the consular level, not as much. You can take an attorney memo with you. I would suggest that you talk with somebody that knows the consular process well prior to going to the consulate for an interview, just to prepare you for potential questions and issues that you're going to face. But as a general rule, the consulates don't really interact with attorneys.
Okay. Rag, thank you for your question. Let us know if you have a follow up. Let me quickly take Akshay's question. So, Akshay says, if I apply for a new F1 visa in my country to pursue a PhD and had already done an MS before and then return back, does the CBP still check all your past documents even though I have a new F1 visa? I don't think it is related to this, but still, if you'd like to answer.
Yeah, so if there is a flag in the system on your records, that flag will pop up immediately when you flash your passport at the port of entry. And probably with facial recognition anymore, it'll pop up before then. So if there's a problem with your record, that's not going to go away. And if there's no problem with your record, they're probably not going to really care or give any attention to it. I would say as a general rule, if you have a master's degree and you're coming back for the next level higher degree, that's not going to be something that they're terribly concerned about it, that's going to draw any attention. If you're coming back for your fourth master's degree, you may get questioned about that.
Okay. Akshay, I hope you have got your answer. Thank you so much for your question. If you have a follow-up, you can also, write to us. Please continue posting. John, here I would like to, also take few Facebook questions. Those questions was actually posted on Facebook groups. So I would like to share my screen and share these questions to you and read these questions to you and try to get an answer. I don't know if you're able to see it clearly or not, but let me read it out for you. So this question is from Chandana Ravi Kumar, and Chandana says, "Hi, I'm looking for any possible suggestions for my issue. I changed my visa from H4 to F1 a year ago. When I applied for SSN, they told me it's showing in USCIS DHS record as H4 status. However, my I-94 has latest F1 status. Can somebody please tell me what can be done to correct my status in records? Any idea, any information on this will help. Thanks in advance."
Yeah, so I guess it would depend on the type of notice you were given on that, but you do have access to DHS Trip where you can troubleshoot issues like this. It's a system that you can log into and describe your problem and ask them to fix their records. Because what it sounds like is the records aren't syncing up quite right. So I would start with Trip. If you don't get any results from Trip, then you do have the access to file a lawsuit because they're denying your benefit because of an arbitrary reason. They're saying you're an F or an H4 when you're very clearly an F1 and you're entitled to that benefit. So I think if you filed the lawsuit, it would get resolved within 60 days typically.
60 days. Right. Okay. So thank you so much, Chandana, for posting this question on the Facebook group. And okay, I'll quickly take one more, but in a bit. Okay, so Akshay says, "Great, thanks a lot." Let me quickly take maybe Namrata's question, and after Namrata's question, I'll move back to the Facebook one. So Namrata says, "Is if DHS requests documents or issues subpoena, what are our obligations and potential risks?"
So if DHS issues a subpoena?
Subpoena. I'm so sorry about that. Yes. Subpoena.
Yeah. So administrative subpoenas are really not that meaningful. So with FDNS, when we first started doing FDNS defense cases and pushing back against these investigations, we had a few overly aggressive officers issue subpoenas. And my response to them was, that's cute. Now you realize that you have to go to the U.S. Attorney's Office and have them, agree to enforce it by going to federal court and asking the judge to issue an order to comply with your subpoena. And oh, by the way, your own agency describes your program as voluntary and not mandatory to comply with. So good luck having a federal court say you're required or obligated to give this information under these circumstances. So, FDNS, no shock, has no longer been issuing administrative subpoenas because they're unenforceable. But if you have an administrative subpoena from ICE or HSI, that's something you definitely should consult with an attorney about because they tend to have a little bit more bite than FDNS does.
Okay, so Namrata, I hope you have got your answer. Thank you so much for your question. Let me quickly read out another Facebook question, John. So this was actually posted by Shweta Ramaswamy. And Shweta says, "I had applied for a change of status from F1 to B1 in June as my unemployment days were nearly expiry and flights were limited. I left in July while my COS was still pending. I recently received an email from DSO office that my SEVP is likely to be terminated as I have exceeded the number of unemployment days. I reported my departure from the country using my university's reporting form. Since my COS is still pending, will I have an issue at the border the next time I arrive? Am I wondering if DHS gets the information from USCIS about my pending COS application? that I have not overstayed illegally?
So, if you're applying for change of status, that implies that you're staying in the country and getting a new status while you're in the country. If you leave the country, that change of status application pretty much nullifies itself, because you have to go back and you have to get a visa stamp for the new visa category that you intend to use and enter the US on. So you your change of status is going to be the problem there.
Okay, okay. So, Shweta, I hope you get your answer. Thank you so much. I hope you got the answer. But in case you have a follow-up or anything, you can write to us. You can comment on this video. We are definitely going to share it with John, or maybe when John comes on the next time for another show, we are going to take it in that episode. But we are definitely going to get an answer for you. That's for sure. But thank you so much for posting your question on the group. And now, John, I think I made a mistake and I took the second part of Namrata's question. So let me also take the first part. Um, okay. So she says, what legal remedies are available if we believe our Indian-owned businesses has been unfairly targeted or harmed by DHS actions? Can we seek injunctive reliefs, damages, or just that? Or yeah, I think this was the second part. Or if DHS requests documents or issues subpoena, then what are the obligations and potential risks?
Got it. Yeah. So, if you think that your company's being targeted, the first step is you've got to gather evidence, right? Statements from the employees, any correspondence from the consulate or the CBP that you can get that indicates that there's a blacklist and that you have been blacklisted. Gather all of that information, as well as any statistical trends that you've got from past employees, and then start the Freedom of Information Act process. You go through the FOIA process, and then you sue the government to request the court order the information be produced that you've requested under FOIA. And at the same time you're doing that, that's when you bring your lawsuit for violating the Administrative Procedure Act. And that's what will ultimately get you the injunction. Unfortunately, the government can screw up your life and your business in the blink of an eye, but it takes you a very long time to fix. And so I wish I could tell you that this is an easy, quick process, but it's not. It takes time and it takes preparation to get to the right result.
Right, right. So, Namrata, I hope you have got your answer. Thank you so much again for your question. But John, again, I would like to come back to my question, and I would like to ask you that, what advice would you, as an attorney, give to the Indian-owned businesses facing these visa revocations or denials at ports of entry, points of entry? So, should they stay quiet and comply, or immediately should they start the legal proceedings?
So I would say, again, gather your evidence. If you have employees that have been in this situation, get them to give you, statements, explain what they're going to be used for, and start building your case. As a lawyer going into court and just making an allegation that the government's doing something wrong, it's very easy for the government to say, oh, they're making it up. We're not doing that. So you need a little bit of evidence to back up what you're saying and to show the court, well, that's not quite right. This is what's happening in reality. So, you really do have to kind of prepare and put your ducks in a row, so to speak, before starting the process.
Okay, but if a business, I think you already have answered it, but still, I would like to get an answer for the ones who have who might have joined us just now. So, if a business chooses to fight, then how long can this battle last, and what are the chances of success given the current legal landscape?
So, the Freedom of Information Act requires that the government respond to your initial request within 20 business days. If they don't respond within 20 business days, then you can go straight to court on the FOIA, and at the same time go to court on your APA, your Administrative Procedure Act claims, that the government has failed to comply with the law. So that would be honestly the best case scenario. Then you're in front of the court immediately and you can, fight out the issue much quicker. If they appeal, if they deny, or if they produce the information or give you a denial of the information, then you have to appeal. That will take a couple of months. And then you have your final decision from the agency on the FOIA, and then you can go to court. Now, the court process is going to take 60 days once the complaint is filed for the government to do a response. And so during those 60 days, if the U.S. Attorney's Office is defending the case, thinks that there's some vulnerability or there's problems, then things tend to settle out within those 60 days. If they fight the case out, it could take anywhere from, an additional 4 to 6, maybe even 8 months.
Okay. And on a percentage level, what percentage of chance? I mean, what chances does a person have to win, these kind of cases?
So it really just depends on your facts. If you have a whole bunch of employees that have, been at different ports of entry or different consulates, all having the same experience, your chances are much higher. If you don't have any of those facts, that might be a little more challenging.
Wow. Okay. All right. Thank you so much, John, again for being here. And guys, if you want to get in touch with John, so here are his contact details. You can give him a call at 844-592-7336. I would like to repeat the number, 844-592-7336. You can also email him at support@wasdenlaw.com. Support@wasdenlaw. I'm so sorry about that. Yes, support@wasden.law. support@wasden.law. You can also visit his website, which is wasden.law. Yes, do reach out to him. And John, before I let you go, any last advice for people, who might be navigating these problems and who are looking to find a solution to these problems?
Yeah, the law gives you the right and access to be represented by an attorney. Your attorney is going to be able to best step between you and the agency and shield you from agency abuse. So take advantage of that right if you're, in a questionable situation. Once an attorney is involved in the process, the government's tendency to bully and abuse goes out the window because they realize they can't get away with it if your attorney's there. So again, take advantage of your right to counsel. It's there for a reason.
Right. And also, you also need to have the right kind of attorney to represent yourself, right?
Definitely. You need somebody that understands the agency you're dealing with and the law underlying it. So you wouldn't want to get a mergers and acquisition attorney to step into this situation for sure.
Yes, absolutely, guys. And yes, and for these kind of cases, I think John would be the best. So you should directly get in touch with him if you're facing these issues or facing these kind of cases or problems. You can again give him a call at 844-592-7336. You can email him at support@wasden.law. You can also reach out to him and check out his website, which is wasden.law. All right. Thank you so much again, John, for being here. It was a great episode, and looking forward to another week and next week and a new episode and a new topic.
It was good being with you.
Thank you so much. Thank you. Guys, I hope you enjoyed this episode, and it was very insightful, very informative to me, and I hope it was to you as well. And yes, John's answers were amazing, very insightful, very deep. So yes, we are definitely going to have him next week with another new topic. And until then, I'm going to see you in another webinar. But for now, I'll have to take your leave. I'm Rajni Bharara. You guys keep watching and keep subscribing to Immigration and Jobs Talk Show. Take care. Bye for now.